Welcome to RegCheck Module 2. In this module, we're going to review a few ways to help you preliminarily sort out the regulatory pathway for your inventions. The goal is to enable you to quickly determine the FDA product classification of your invention. Once that's determined, the regulatory requirements you'll be facing will begin to surface. As an example of the searching process, we're going to use a medical device. And as you'll come to see, the research process, whether it be a device, a drug, a diagnostic reagent, or whatever, is very similar. The key is how to search. Just a little background. Problems with importation and sale of unsafe drugs was very prevalent, and as early as 1848, the U.S. government passed various legislation to try to control things. But it was not until 1906 that legislation was actually passed to form the agency to deal with the problem. And from that, an endless series of additional legislation and regulations followed over the many subsequent years. Requirements got very technical and more scientifically based, starting in the 50s on into the 80s. And in 1976, an amendment was passed to the Food and Drug Act to include medical devices. There are three classification pathways to get a medical device cleared or approved by the agency. Class 1 is intended for very simple surgical instruments, and basically for this, you essentially self-declare your device into that category, register with the FDA as a company, prepare a quality management system, and you're in business. You don't need their blessing or to meet with them per se. Of course, you can be inspected once you file, so you need to make a proper decision up front and be prepared for the inspection. Class 2 is a category that's very popular as it attempts to reduce the workload of the submission by claiming that your invention is similar to another invention previously approved by the agency. There are three different scenarios in this class. First, a few years ago, the agency was made to realize they overdid the regulation of some devices and they reclassified them from Class 2 to Class 1. And this, of course, has proven very helpful. But in order to otherwise qualify for Class 2 designation, you need to locate what is called a predicate device and prove that your device is substantially equivalent to your chosen predicate. In some circumstances, you will only need to do bench testing of the device, and in others, you'll need to do clinical work. This process is referred to as the 510K process, named after the particular paragraph in the legislation that offered up this particular option. So now you have two new regulatory jargon terms to impress people with: predicates and 510K. But all of the above typically requires less work than Class 3, which is reserved for both novel and, let's say, more scary devices, ones that could cause significant potential harm. These are pretty much treated like drug-related approvals involving animal and sometimes a series of clinical trials, depending. And last, if you're working on a medical app for patients or for use by physicians to guide their decision-making, or regarding certain devices like smartphone applications or Apple Watches, and it's all based really on how these are used, they are typically not considered a medical device. And because this is a very popular area of development and also of confusion, we'll have a separate module on helping you navigate that distinction. Back to predicates, your new regulatory word. Proving you are substantially equivalent means ideally that your device has both the same intended use or medical application and the very same technical characteristics as the predicate. Now, there's some wiggle room provided if this is technically different, but it still requires you to prove it is safe, and typically this will drive you into clinical research. And lastly, if you can't find a predicate, you might be eligible for what is called a de novo 510K, which acknowledges the device is different technologically, but is of low risk. In other words, unlikely to hurt someone. Here you are for sure going to need to do clinical research. So let's move now onto an example where we're going to assume that you're planning to invent a device similar to a predicate. I was researching a talk on the history of the FDA and came upon this ad in Popular Mechanics that wouldn't be permitted by today's standards. With any medical device or drug, you need to prove what you say, and I thought that this was a seemingly ridiculous idea, which looked like a light bulb with a head fitting sort of lampshade. However, some days later, I was quite startled to see two separate full-page ads in an airline magazine essentially claiming the same thing. And what really caught my eye was the mention of it being FDA cleared. So when I got home, I decided to research just what that was all about. And that will be the process we'll learn about. I simply went into Google search engine and typed FDA clearance hair max. And by using those specific search terms, FDA clearance, and then the name of the company, it not only showed me where I could buy one of these hats, but identified, more importantly, some critical links that would take me very painlessly into the FDA's website. So I clicked first on the 510K summary. The 510K summary link is probably the most valuable link. And here we have one excerpt from what is a couple of pages of that summary. And you can see that the clearance required them to do a randomized control trial. In the next module, we'll dig deeper into the exact trials that the company did and where you can find out about those. Also, interestingly, this very same summary document includes a clearance letter, and that lists the company information and also an independent regulatory affairs consultant. And while this isn't always listed, as sometimes a regulatory affairs professional works directly for the company, when it is, it can be very helpful to interview that party. They could be someone you might want to interview to hire for your project because along the way, they acquired a lot of very specific knowledge about how to get a technology like this approved. Back to the Google search. If you then click on the pre-market notification link, it'll take you directly into the FDA's website onto a table. Here's the table, and every clearance or approval is posted into a table like this on the FDA's website. Take a closer look at the table. It contains some other very good information and links. This company made a bunch of filings for their product over the years, and this appears to be their very first filing, and has a particular filing designation number up at the top, called the 510K number, all of which start with the letter K. Also in this case, you can see the person at the company who was making the FDA submission. Whoever is listed here is also worth tracking down, as they may not still be working for the company and can often be very knowledgeable in your specific space and potentially available. Secondly, this table reveals the FDA's product classification code, which in this case is OAP. If you then click on that code link, it'll take you to another page. This is the information table that addresses the product code. It includes a definition, which in this case, includes a rather specific indication range, and it even lists details of how to apply the product, which is a little unusual, kind of setting a standard for this category. And it shows that it was a Class 2 device, which means that even though HairMax in their advertising claims to be the first laser-cleared hair growth device, they must have found a predicate. Their 510K summary will list what that predicate was and should have enumerated feature by feature, specification by specification, the substantial equivalence claim and argumentation associated with it. So let's see what they used as a predicate. So if you go back to their original 510K summary page that put you onto the FDA's website and click on the summary, you can see what they chose as the predicate device. So in the 510K summary, you can see they list 10 different devices, some of whom actually appear to be used for hair removal, not growth. By today's standards for 510K submissions, you couldn't do something as wild as this and really get anywhere. You would need to specifically list each parameter of your device and compare it to the predicates. And you would need to pick preferably one or at the most, say, two other devices. Although there's substantially equivalent argument paragraph elsewhere inside this summary document, covers the bases pretty well with regard to the safety and efficacy. The broad swagger at 10 devices really wouldn't work today, but it got a clearance back in 2006. Regulatory requirements can change over time, which is why it's helpful to ultimately work with an expert who has recently done something as close to what you are working on as possible. Some of the larger medical device regulatory consulting firms actually hire reviewers right out of the FDA and having access to someone who used to actually work for the department which will be reviewing your application can be a very critical time-saving asset. Lastly, by changing the search term in Google, simply keeping FDA and adding maybe an S to the word clearances and more broadly including laser hair growth device, produces a very good list of other folks who chased HairMax through this approval pathway process. Again, more information that can be gleaned by going through these one by one. Until you get more familiar with how to search for things on the FDA website, it's probably best to use a search engine like Google. Placing, for example, the same search term that I did onto the FDA's own website search window produced an endless series of entries, some of which had nothing to do with HairMax. All the information you need is on the FDA's website, but it'll take you some time to learn how to navigate it. That's why I prefer to use the Google search engine to get you started. The FDA staff regularly prepares guidance documents on many submission-related subjects and topics, and often has one on the particular device that you're pursuing. Look for it initially on Google. In this case of the hair growth lasers, there were only a variety of non-specific guidance documents on different sorts of lasers. It wasn't that helpful, but most of the time there often is something quite specific and it can be quite helpful. By clicking on the link shown on this slide, it'll actually take you to a very specific search area on the agency's website, and you can attempt to search more specifically that way as well. What can really be most helpful and is often asked is how to get a copy of someone's submission. You can request one through the Freedom of Information Act, but it typically takes years to get any response. However, there is a company called FOI Services that regularly makes requests for various documents, and if they've obtained the document, it's available immediately for a fee. So in our case example, I simply typed the K number of HairMax into their search window, and it produced the following. Well, bingo. They have available HairMax's original 510K application, which was 418 pages, and by adding it to your cart and providing your credit card, you'll have immediate access to an application that was cleared. A couple of important qualifiers on these types of files. First, before FDA releases the files of a company, it gives the company an opportunity to mask out or white out proprietary information. The company has to argue with the agency what is proprietary and what is a trade secret. However, the agency is fairly lenient on this. On the other hand, I bought once a file that was not redacted at all. It just depends on whether the company was smart enough to do so. And they can't redact clinical related information on their trial, for example, as this isn't proprietary. And they also can't redact certain test results. That shouldn't be deemed proprietary. And in my view, even if an area is blanked out, the headings are there, and you can surmise from the headings that certain testing was required, even if the results are redacted. But what is also extremely valuable is that this file discloses the direct correspondence between the FDA and the company, which can be particularly revealing, and that it highlights the agency's specific concerns and arguments between the two, and can help you learn how the company dealt with those. Bottom line, if it's available for purchase, buy it. The key here is to find a device or drug similar to your invention. Just find something comparable and use this type of search process. Let's summarize. Well, you've learned about the 3 different medical device classifications and have added 3 important terms to your growing vocabulary of regulatory jargon: predicate, 510K, de novo 510K. I can promise you that you'll impress people at your next cocktail party. You've learned how to determine the classification code and see the highlights of a product's claim performance. Who made the submission can help you search for a domain knowledgeable consultant. And lastly, how to mine for guidance documents and maybe even purchasing a competitor's submission. That's a lot. In our next module, we'll examine how to determine your likely clinical trial strategy and how to budget for one. Thanks for listening, and thanks to our sponsors.